Okay.
Because the Crown won't be interested in a full-blown excessive force trial. Like, these things generally take 3 days for me to litigate them at trial.
Right.
Over a ticket. So it's a pretty effective defense.
Okay. Now, you made, you do talk, again in your brief, you talk about the distinction that you may have an election in some cases. For example, of course, there's 2 trial courts. There's the lower court, provincial court, and then in Alberta, there's the Court of Queen's Bench, and Ontario, there's the Superior Court of Jurisdiction. Tell me about the distinctions that you think about that. Tell me about that.
Well, I mean, that's a decision that's not much different in these cases than any criminal defense lawyer has to deal with. Now, use of force cases.
Right.
If you're not satisfied you've got full disclosure, if these police officers are not telling the truth in their reports, you might want to go to a preliminary inquiry. So elect Queen's Bench.
Okay.
Or you might want to just waive you might want to go to Queen's Bench and just waive the prelim.
Right.
And then a lot of times I do it that way because you don't want the Crown to have a choir practice either at prelim. In terms of electing overall between Queen's Bench and provincial, I can tell you that what I do is periodically I look at the roster of judges in the provincial court and then the roster of judges in the Court of Queen's Bench, and I calculate the odds.
Okay.
And
what are they? You give some
right
numbers.
now.
You give some numbers. You do give a few.
Well, I won't tell you what the odds are, but right now, it's Queen's Bench.
Right.
You got better odds, I think. It used to be the other way around.
Right.
But I don't think so anymore.
Okay. And that'll be very locally driven. You may want to, again.
Oh yeah. Like I'm talking Edmonton.
Right. Yeah.
Edmonton,
Exactly.
Right. And if I was to do a case in Calgary, I'd be asking you.
There you go. I tell you, and we'd be awesome. All right. So we're now. You also have a section here about bad character evidence and propensity. Could you tell me about that?
Sure. Just a minute here. Oh, I did mention this business about the. I put the odds in this paper.
You did indeed.
So if you want to see,
that's why I'm leading my witness.
I guess if you want to see the odds, you can read the paper.
There you go.
Which I understand you're going to post.
With your permission, of course.
Yeah. Okay. Interesting. Yeah. Well, and also I mentioned about jury elections, and it may be that I think the public is generally becoming much more aware that police officers do beat up people, and it's not rare.
Yeah,
and they're also aware that police officers do lie.
Yeah, the Star has been very proactive on that. Yeah, the Toronto.
Well, yeah, exactly, and
even on the Alberta stuff like that.
Yeah, and with the cell phone videos and everything. Yeah, it's so I think it's an unfortunate thing that the public is getting a sour attitude about police officers, but. It's probably a good thing overall because it's going to force, I think, the police to clean up their act. But having said that, I used to think, well, I'd never go in front of a jury, never elect a jury on an excessive force case. I see that Sammy Yatim case, I think, is in front of a jury.
Okay. In
Toronto. Could be wrong. But now, it'd be interesting. I think you might do pretty well in front of a jury with the right kind of facts. Okay, so you asked about.
We were talking about. You've got a section here talking about cross-examining officers with respect to bad character evidence.
Yeah. Okay, so there's an old case called Scopoletti out of Ontario, where it's a leading authority, and it says that the victim's propensity for violence is relevant if you're advancing self-defense.
Okay.
And that is propensity for violence known to the accused and propensity for violence unknown to the accused. Because if a person has a certain propensity for violence, then it makes it more likely that they were the aggressor. in any given situation.
Right.
If the propensity for violence is known to the accused, then that informs what kind of force they would use.
Right.
Same as a police officer. If a police officer knows that a suspect he's dealing with is violent and hates police officers in general, that will inform the officer's response.
Right.
So you can call evidence in the Scopoletti situation, in the ordinary case, of actual acts of violence on the part